Welcome all. So good afternoon, good evening, folks. So welcome to the special talk show with Mary Kennedy on this right time, so which is on June 25th, 5 p.m. Central Time. So we're talking about a special, the recent updates on the visa bulletin and so the current H4 concurrent issues we're going to be talking about here. So thank you, Mary. Thanks for joining in, and thank you very much for your time. I know it's a very short notice we were able to turn around. So thank you very much for taking this. So good afternoon, good evening, folks. Welcome to the special Mary, over to
talk
you.
Show with Mary Kennedy on this right time, so which is on June 25th, 5 p.m. Central Time. So we're
sorry, Mary. Please.
Yeah, I think it's echoing, right, Raj?
Yes. I took it off. So
okay.
Get started.
All right.
Yes, Mary. So we can get started. Right. Over to you, and then we'll go with the questions. So we have a few people already joined. First, we'll go with a little intro, and then we can.
Sure. Yeah. Good evening, everyone. So we are at CST, so it's almost 5 end of the day. Trying my best to be energetic and then address as much as possible. It's always me and Raj are very. Like the energy that comes up when we talk about immigration is amazing. So I'm looking forward. I know like you're looking tired, but that's fine. You'll overcome it in another 5 minutes. So, all right. And then looking forward for your questions and your conversations and the interaction that's going to happen. And one more thing as a disclaimer, this is not a legal advice because it's going to be totally not, it's just not anything that we say over here cannot be considered as a legal advice. That's the only thing. And then let's go back to the questions.
Wonderful. Thank you. Thank you, Mary. I mean, as I said, that's right. So you will smile and, the people's questions will give me more energy as a respect to the time. So thank you for that. And thank you for your support. So first, we have a few people on the ground, who's already on the Zoom. So probably we can go get started with them. Folks, if any of you have any questions, please unmute yourself and type here. We have Radhika here. Radhika or myself will facilitate to take the question forward, and we can go that way. So please raise your hand so that we can go accordingly. Aditya, so you have some question, right?
Hey, this is Aditya from Vision Tech. Hope you guys are having good time. I'm just struggling with some, technical issues. I was unable to hear you guys, and I got you. Okay, I'm having one question which I just, got a couple of candidates recently. They were having 221G yellow slip kind of thing. And one guy, expired that 221, tenure, like 1 year, or one is still in the 221G. So what we will do in that case, like we'll have to them phrase apply H1B, or will that be like, transferable or something like that? My concern.
So Aditya, okay, Aditya, I'm understanding here as you're an employer, correct? Okay. All right. Yeah. So some of your employees who went for the consulates has the 221G and some of them are even 12 months or later. It's almost like, after they applied for it and still under administrative. Did you get any decision or still just like that? It's still under the administrative.
Sorry to interrupt you. Like, I would like to correct you here. Those are not my employees. They have been, applied through different organizations. But now they are just approaching me that what to do, like because their employer is not responding them.
Okay, got it. Yeah, so here it is. See, 12 months is the validity period, actually. So within that has to be decided for a 221G. If not, even if it's with the same employer, all that they have to do is they have to redo another filing, let it be a new H1B or anything. So the one question over here, they are not cap exempt. The reason being they were never given the stamping. So without a stamping or, they didn't start the change of status over here, they are considered still as they don't qualify under the non-exempt. So in that case, they have to go through the lottery system again. As you're not the earlier employer, we don't know exactly the reason for the 221G, because all that they say
Yeah,
is
they were
even
asking, supporting documents, whatever they
and
have,
all those.
employer has,
Right.
given at the time of LCA. So
All
they were
right.
asking for all the documents again, okay, in the
Right.
consulate.
Yeah. So
So
the same employer, I wouldn't advise to go
Hmm.
for it, but again, with another employer, definitely you can file them under the lottery and then just get them selected
oh,
for a
again,
new.
so they'll have to start afresh, isn't it?
That's correct. That's very correct.
Okay, got it. So
All
my
right.
concern is that. Okay, thank you.
Yeah. Sure.
And the second thing is that any update on fee hike of lottery and other
Yeah, the
stuff?
fee high, yeah, right. The fee hike might not be 90%, 95%. It's not going to happen as the comment period is not over. And so, they have to come up with how the lottery. So then not much of any news from them on the new H1B. So we are all hoping that it's going to be the same process adopted like last year. So in that case, right. So with that, they have to finalize the fees and everything. So hoping that it will not be for this year, but definitely it's going to be for the next year.
All right. And other thing, like I received one email from your company that you guys are requiring some information, whatever we provided last year. So the
Right.
same information in the Excel sheet, and we'll have to fill with all the
Yeah, the
applicants'
details
details
and then
and
provide it.
send it across to legal at your
Sure.
domain.
Yeah, that's correct, Aditya.
So that I'll have to do before 22nd February or what? Like,
No,
is there
we
any
are
date?
yet to get the dates, but as much as possible, right? Just keep it collected, and then we'll just once it gets closer, then we'll set a exact deadline, and then we'll just get it collected from.
Okay. And while providing, how soon we'll have to make the payment to your the
That
same?
and all we can talk about it, right? Like this, you can always call the office, and we can sort it out.
I understand. Yeah.
Sure.
No, sure. Because
being
I was waiting for all the this hike drama and all, because we are
right.
not
Yeah.
knowing.
So it might
who's-
not be happening. I think we even sent an email on that actually saying that, this fee hike might not be reflecting on this year actually. But again, we are not guaranteeing or assuring you because it's going to be the a decision of the USCIS. So, but for now, we can say that it's going to be the $10 registration.
The only concern is the lottery one, because it will be huge hike, 20-50%. Like it's from 10 to 15. It's a
Yeah.
huge.
Yeah, that's correct. Yeah, I understand. Yeah.
It'll
Okay.
be.
All right, Aditya, I'll talk to you later because
Thank
other
you.
people, might
Yeah,
have
sure.
other questions.
Sure. Thank you. Thanks for your concern.
Thanks, Aditya. Thanks for joining it. And
Mhm.
no, guys, whoever is on the Zoom chat, so please raise your questions and please raise your hand, and then so that we can give an opportunity to raise or ask questions to the immigration attorney sequentially. So just please raise your hands or type your question there in the chat box. So before we go to the next caller, so I have a couple of questions asked from the team. So one is from somebody in California. And I'll read out the name personally. You, Mary, but they are currently on F1, and then recently got confirmed while so they did a change of status from H4 to H1. So they are planning to visit India for a family emergency in May. And her husband I-140 is not certified. So they have a couple of questions. So one, can I quit studies anytime and after my H1, my husband's H4 approval is approved, so the GC will be straightforward, is the first question. And second thing is, if I go to India on F1 and I need to go for a consular interview for stamping, once I come back, can I convert back from F1 to H4 EAD? So she's, just to keep it simple, so she's currently on F1, she did the change of status from H4 to F1. And so her question is like, if she go to India and come back, if her husband's get a I-140, can she convert from F1 to H4 EAD directly?
Yeah. So for her first question, right, can I quit studies anytime after my husband's I-140 approved? It means, she's asking is whether quitting her F1 because being an F1, she has to maintain her minimum credits and everything. So all that she's asking is, can I convert myself to an F1 to H4 Yeah, definitely. I think that's a wise thing to do because it has its H4 EAD. And as you all know, or we can quickly talk about it at the end of the questions or something about the concurrent processing that's going to happen with the H1B itself, the H4 and the H4 EAD, right? For this kind of a situations, I would say that's much better for them to convert themselves from. So the only reason that she would have gone for an F1 is that will give her the OPT, the employment authorization, or in worst case, the CPT, which might authorize her to work on campus for the school, which is not available for H4 without an EAD. So I would definitely say that it's better for her to, as soon as after the I-140 gets approved, to make herself convert to H4 and then apply for the H4 EAD as well. And then for the second question, she's asking, is it going to affect any way because I travel, or, that's what it is, right? Yeah.
Yes.
So I don't think, that's going to be a problem actually. She's, quit studies or anything doesn't have on her GC or any processing. It's totally going to be a smooth process. Only thing is if she is going to be on an F1, that's when, because on an F1, it's going to be, they should not have the intent. It doesn't have a dual intent. So being on an F1 is different. So she can always go back to H4. That would be the better thing to do.
Got it. Thank you. So there is another question from Sukita. So she's on currently in L2. I mean, so this is about the recent update. So she's on L2 visa. It seems her spouse's visa extension has been processed and approved, it seems. But my extension request has been submitted and I have received a receipt as well. But her I-94 is about to expire by end of this month, it seems, which is 131. If the approval does not come through before 131, so her employment would be disconnected. So is it still be the case with the new, or with the new updates? How is it going to be impacted?
See, actually, yeah, that's a good question here. When they started the concurrent right now, definitely it's going to be expected. They'll have the resource to process the EADs, which were not happening earlier, which was because of the biometric. And even when they stopped the biometric, they did resume the process of concurrently making the decisions on the H4. Her case is interesting, and the reason being, being on a L2, all that matters is just her approval of the L2 status. That would have given her the authorization to continue to work. But without that, but definitely, I think, with the settlement that came up last week and USCI is being aware of it, even there were some other attorneys talking about this in our attorneys forum as well. Even it's not our office, but again, prior to that, they said like the last 2 weeks before itself, they started some of the H4s as well in the premium processing getting approved along with the H1B and the H4 EAD. Even before the settlement agreement might or might not be connected to this, but I would say make a call to the USCIS. I know like the e-request is there and MS chat is there. That might not help. Just let her make a call to the USCIS and then ask them about this. And definitely, I think with the implementation of the concurrent processing, this will definitely help her to get it approved before 31st. If in worst cases also, like the one provision is earlier, it was not very clear if the person has to be completely out of job and then, what they have to do it. But recently, right, like they can take a break rather than, they should not be working, to make it very clear. They should not be continue to work, but at the same time, they don't have to completely rolled out of the office, of the work. So they can be on a break. And then as soon as, I'm very sure, making a call to the USCIS is going to definitely help her getting this, L2 approval. So she can choose to do one of them.
Thank you. So I know there are a few folks joined recently. So just to reiterate, guys, so if you have any questions, please drop your question in chat window. So we'll just go over round table, in the sequential order, or please raise your hand. So we have a question from Hema Uday. Hello, Hema.
Yeah.
Hello.
Yeah, Hema, go ahead, please.
Hello, Mary. This is Hemeshwari Hemli from Texas. I just have a couple of questions. I'm having H1 and I received EAD. So can I change company at this moment? Also leaving my H1, canceling H1, just with staying with EAD. One question.
Okay, so
Do I
your
need to should I? Sorry, yes.
yeah. So your question is, like yeah, right. I got your
have
question
H1.
here.
Yeah.
You have an H1B and then you have an EAD, valid EAD as well.
Mhm.
So like for you, it's a little different than the other
Mhm.
basis. Definitely, your 485 has been filed 180 days prior to that. At the same time, your I-140 is not reinstated. But like just coming back to your specific question, yes, as long as you can switch your employment based on the EAD. You don't have to maintain your H1B because the 485 has been filed and it is pending. So with that basis, based on the EAD, you can definitely switch your employment.
And I don't have to go with H1, right? No,
No, you
just
don't
with
have
EAD.
to. That's correct.
Okay. Okay. My second question is just, so is it possible for me to travel? If in that case with EAD, can I travel? I have got the travel
Yeah, you
document
have
also.
an advance parole actually. It's not the EAD
Yes.
doesn't have
Oh,
anyone yeah, right. Yeah. So advance
sorry.
parole allows you to travel and you should be fine to travel and come back.
So it's still okay. I can travel, change or travel with with the EAD and parole, I can go and come back. I don't have to go in H1, right? Just
No,
to travel, I don't have to maintain.
no, you don't have to.
Okay. A lot of people say that I have to maintain the status until we get through the GC.
No, not really. Not really.
Okay.
You
Okay.
can, if you want to. There are definitely, advantage when you are on a H1B because it's always, we also advise them to maintain the non-immigrant status better than depending on the 485 is not as such a status actually. It's just adjustment of status over here. But doesn't mean in your situation particularly, I would say just you can travel and then come back.
Okay, just I can leave the H1 completely, right?
Yeah, that's
and
correct.
there is any period that I have to hold on to the H1 until I start using the EAD, like 6 months or something like that.
Yeah, 180 days. I think you passed the 180. 180
okay.
days.
Thank you so much.
All right.
Thank you. Thank you.
Okay, sure.
Good. Thank you. Thanks, Emma. So Mary, before we go to the next question and next topic, so can you just briefly summarize on the findings from the recent visa bulletin?
Oh, the visa bulletin. I'm not prepared for it, Raj, actually.
I'm sorry. So just
Yeah. No, I want to, whatever we do, like let's talk about it in detail. So I didn't expect that you'll talk about, but we'll do another call to be honest. But again, I will talk about something, so very I know like with the layoffs and everything going on, right? What should be the options and what about the compelling circumstances, EAD? We'll just quickly go through it, Raj.
Okay.
Okay. Yeah, right. So with the mass layoffs coming up and everywhere I see, even, through all these common groups, Indian groups and, everywhere in the Facebook as well, like all that they are saying is, like so first thing I'm telling you is you had come a long way. If you're employed with all these bigger companies, you don't know what power you have or what you're holding on. You didn't get into it just like that. Even tougher than any H1s or anything is getting into all these interviews and getting it done. So definitely, like keep hope. And then, like even I just came in when 2001. So there are so many things that happened 2001 and then, 8 and then, all these happened, and then now with the COVID as well, right? Initially, when there was a lot more of chaos when me or other people for the community purpose used to do this free webinars. All that is the furloughs and so many things. How do I maintain my status? And honestly, 2020 the pandemic was more serious than now. Without travel to India, and if I'm going to stay here without what I'm going to do, so many questions were there. Still, most of them crossed that phase of it, and you were able to get back to your job or work or anything. And even people who moved to India, I know personally as well, like they were not so desperate after being there for a while, 6 months. They were just still, they just still wanted to, but still they're just still delaying whether I should be coming in or what should I be doing. And, like still they just keep that as hope, and then not to spread around her as well, like the whole economy is going to be, you're in a better place when compared to all other, field of work and career of work. So you are in need, and the position keeps, maybe definitely there is something going on. I'm not minimizing that part of it, but at the same time, just not to create any panic or anything about it. Just keep that hope, and then there are options available. So even before, like USCIS came up with a recent memo about the compelling circumstances or change of status, which they themselves are encouraging. Even the very, the lead attorneys were also saying that do not, like if you don't have a state, you're not able to find a job within the 60 days. First, from the day one, I was started saying that it's not like you can always change your status to that of visitor B2 visa. In worst case, if you're not able to find a job and a new employer, or if you don't have a H4 or an F2 or an L2, then immediately, changing yourself to maintain your state. We did a lot as well. Actually, within the time period, just we helped them up in a day to file the visitor, B2 status. And then once they found their job, then we made them to file their H1Bs on a premium processing. And then when they get approved, definitely you cannot go back and withdraw this B2 just because you got another H1B and that was applied for. That's not the right way to do it. But at the same time, you have so many options, but depending on your situation, definitely you have to consult. And then we as well, we did so many, I remember that was the last day for the Thanksgiving. Before that day, me and one of my paralegal was coordinating to file for an B2, and she got a job by the first week of December. Just all that matters was 10 days time period she has to wait before she has to find an offer and then join them. Actually, it's a very big company as well, the new company as well. But the 60 days period she was going through, she used to call us, what happens, I have this offer, can I take this, or will you be able to do it if I confirm it in a day that my B2 has to be filed within the 60 days time period. So many questions that we reasonably understand that, but at the same time, more important is like someone who can help you out with a situation, and then find someone, and then you can always go through that and then change back to that of any new H1B. In worst case, yes, like it might take a month or two or more than that as well. You don't have to worry about it. Just keep looking for it and you'll be fine.
Mary, that's a very insightful information. So I have another friend, so somebody just texted a message. Seems like one of their friend had to leave the country because of the layoff, H1B layoff, and now if you want to come to another employer or anybody, so is it what is the kind of approach?
Yeah, so that is the one criteria. If you left the country, the problem is like, that's one of the reasons we insist on to go to B2 status, and then, just stay over here and then do it. So once they leave the country, the problem is now the H1B can be filed under a premium processing with a proper offer. But when they have to go, right, they have to come back, enter back to US only after the visa stamping. But the visa stamping slots are also very much opening up right now, and there are so many Dropbox appointments available. Already they have been over here, so obviously they can qualify for the Dropbox. And even there was a note, the other day it was getting circulated, Mumbai offices are even working on Saturdays to fulfill that long line of people who had been waiting for the interviews and everything, particularly the new, the CAP H1Bs and everything, like the stamping period and everything. So with that, all that matters is they have to just file the H1B on a premium processing, and then find a Dropbox appointment, get a stamping, and then come back.
So the question, particularly they have is like, so they have a valid visa, but the employment is not.
If they have a valid visa, that makes it even more as simple as possible. All that they have to do is go for a premium processing with a new offer, and they can just use the same valid visa and then enter back at the port of entry. They have to show that new employer's H1B approval. because the H1B will be approved with the consulate approval. So all that they have to carry is, even now, everywhere the consulates, the port of entry, they're all accepting even the copy of the approval. So it will be without an I-94. All that they have to do is they have to enter the port of entry and then show them the new H1B employer, which was filed recently, and then get a new I-94 for the 3 years period.
Okay, perfect. So, so they don't need to have a new employer visa. All they need is a.
No, they don't have to go for a visa at all because they have a valid visa. So it can be with the prior employer or any other employer. It doesn't have to be with the same employer.
Perfect. Thank you. Again, guys, so any questions, feel free to drop us in the text chat window, or unmute yourself or raise your hand so that we can just go around the circle.
So you can even put it on your the message or this one.
Yes.
So then, so what is the purpose of the the compelling circumstances EAD, right? How does it work? So the only option, it's between whether you want to change the status to that of a B2 or an H4. I would say if you have an H1B spouse, then definitely instead of B2 or any EAD compelling circumstances also, you can definitely look at it to go through an H4, because that's much easier. And then rather than any other status, say if you don't have it and then you're looking at the option of only looking at it. So the compelling circumstances EAD, the recently it was not filed actually. So how long it's going to take is a question. So, but again, it's worth it if you feel like H1B is going to take time or anything. Any reason it's not like any reason, even though the health reasons are given or the financial reason. Financial reason, obviously, if you lose the job and if you're the primary working, and then you can also, as well as if you have your health insurance tied up to that job and you have a family to support it, so, and also your children are in school, and in the mid of the year you cannot be taking them out of school and then taking them traveling to to India or back home. It's not a possibility. You can put all these as the compelling circumstances, and then how it helps other than the B2 status is obviously any employer will be interested in hiring an EAD than a H1B individual. So you'll have little more of openings that is available being on a compelling circumstances EAD. But at the same time, during COVID, definitely as a financial compelling reason and the pandemic and then the no travel. So they were able to approve it, but it took a very long time. So 9 months to 10 months, all that happened was they were able to stay here. It's, without any other attachment or status, but at the same time, you cannot work till the EAD gets approved. But with the so you can either choose between a B2 or an EAD. You can definitely should have, talk to an attorney, understanding the situations and how strong is your case and what is the possibility of a H1B or an offer that's going to help you with. So all these are there. And also one more thing you have to keep in mind is once you convert yourself to the B2 status and then your H1B is getting, so there is a difference. Within the 60 days period, if you're filing your H1B transfer, then you are eligible to start working immediately without waiting for the approval. But when you convert yourself to another status like a B2 or a H4 or any other status, and then you're applying for your H1B, you're not eligible to start working immediately just with a filing receipt notice. Keep in mind, many of the employers, if they do it on their own or something of any other, like a paralegal help or anything, that will definitely make you out of status, and they just file it and say that, your case has been filed and you're good to file, work. That's very wrong. If you have filed even a B2 status on the 61st day or a 60th day, then you have to maintain your status, and all that is you have to go for a premium processing, get your H1B approved, and then only you can start your employment with a new employer actually. So keep in mind, that's very important. So with all these underlying criteria, so you have to compare yourself how far it's going to help you. And also EAD doesn't have a premium processing. So if it's a H1B, so for example, you want to file for a B2 or an EAD on a compelling circumstances, We don't know the timeline, but I'm assuming it's definitely going to be 3 to 4 months because they came up with the memo, they understand the situation. And if you really qualify and your circumstances are compelling, and then there is a possibility that you're going to be approved of, then it's an option that you can choose to be on an file for an EAD rather than a B2. But depending on the situation, you have to decide actually. So, and more than that, say for example, even if you had filed for another criteria is, if you have filed for an EAD compelling circumstances, you cannot be filing for a change of status within US. So there are many things. I'm just giving as much as possible information. At least you'll hear it. And then when it comes to a place or your friends, it doesn't have to be you. I know, like, it's all giving the information at the right time to the people, helping the community as such. That's the reason for this call as well, right? Why we have to do it on an evening after a very long day, just to help people understand it, be aware of it. So in this situation, there are many things to consider, but there is an option. Try to talk to an attorney, find it's worth the time or the money for the initial consultation that needs to be done. There are many people, even including us, providing if there is a layoff on a quick 10 minutes call. I'll just get into the call, let them know what could be the minimum options available over there. So just, understand that and then do it. Raj, is it too much of an information or?
No. So I mean, I think the taking a little time to understand the process the data. So pretty much,
Yeah.
very good information. Thank you very much for that. I think I have a question from Durga. Hey Durga, you can unmute and you can raise a question. Hello. Yeah, I mean, basically her question is, if the employer can sponsor a POM or green card for a H4 EAD employee rather than being on a H1.
Yeah, see, the green card is for the future position. So definitely, like it doesn't have to be, even they don't have to be employed by the employer itself. They can, and a green card process can be started even being on F1. If you're, because I know that with the lottery system and everything, it takes so long and you might not be qualifying or getting into the lottery for 3-4 years. So if there is an employer who's willing to do it, let it be H4 EAD or, F1 or anything. So only thing is that, the financial ability of the company when it comes to the I-140 stage has to be seen that they will be able to support you. If they are on a H1B or any other, they are working with the same employer. So then it becomes easier for them to support the financial ability of the company, which has to be done at the time of I-140. But however, there is no restrictions. You can definitely ask your employer to start the process being on the H4 EAD, and then they can start working through it. And with the prevailing wage, and it's taking a very long time. This has never happened even during the COVID time with the Department of Labor. The prevailing wage is taking 6 to 7 months easily. If it's a software developer, that's the only wage that is coming up in 5.5-6 weeks. But if you go for any other title, then it's totally delayed, even 10 months, 9 months, and then you are waiting for it, and then the recruitment process starts, and the perm as well is taking almost 9 months. They're just processing in the month of May actually now. So with all these delays, I would also say that even though you think that I'm just in my first year, second year, whether I don't know whether I'm going to be the same employer or not, you have chosen them for a reason. Just ask them, connect with them, talk to them, and then, you can definitely, just start the process slowly so that you are not in a last minute of, a filing. I'm seeing so many people on the 5th year, 6th year without proper base. And then for the same reason, we have to make them to B2 and then ask for them to for the H1B. And so many criteria are, getting very tough at this 5th year of it.
Yeah. Okay, cool. And I think we have a question from Kumar. The guy, I hope you got the answer for that, and which is pretty straightforward. So you can reach your employer for that. So, and thank you. And next we have a question from Kumar. His question is, he has a question regarding the 60 days grace period on H1B visa. He's on H1B visa, and this week he will be the last week of my work with my current employer. Can I stay here for years for one more year to do this?
No,
Yeah.
actually, I don't know what do you mean by, like 1 year. Actually, you cannot. So it's only 60 days if there is no employment, or if you don't. I think we were talking about it, Kumar, in detail about actually the same question for you. So you definitely have to switch to a B2 visa. I think, like after the call, you can go back to the recording as well, because I don't want to for other people's,
Okay.
so that's what we were discussing in detail. So the better option for you, Kumar, is you have an I-140, which is very good. But only thing is you have to immediately convert yourself to a B2 visa for the, just to maintain your stay over here. And then once you get into the B2 visa, you can always, once you find an employer, definitely, like you can apply for the H1B from the B2 to that of the H1B. And only after the approval of the H1B, you can start employment with a new employer.
Okay.
With the
Thank you.
B2, is there any term like 6 months? Is there any
The B2, yeah, the B2 will be for 6 months, but what happens is the processing timeline is 10 to 12 months at this time because of during the COVID period when there was travel restrictions, right? All these, the parents and whoever came and they all converted to the B2. So there is a very long delay. Delay means, even more than a year and a half and all those things. So you cannot expect any decision on the B2, but USCIS is, like they proactively, I would say, appreciated in the way that, they are not approving a B2 as soon as they take the case, actually, or H4 immediately. The reason being, if they approve it, then you go back to the H4 status, which is not the one that you wanted to be. Always you wanted to be on the H1B. All that you did is a bridge petition between them, actually, right? You are just maintaining your status over here just by filing an H4 or an F2 or an B2. You don't want that status, actually. So the understanding that they are issuing an RFE and then asking you whether you want to continue on your, the RFE is very clear. They're mentioning even you looks like you had filed for your H1B after filing this B2 or H4. And then, like, do you want us to approve this case or what do you want? They're giving an option. And so obviously your attorney or whoever filed for will be saying that, no, we are holding to the H1B. So we are good on that.
Okay. Thanks.
Good.
Can we work in the B2, B1, B2 visa?
No, you cannot. You can just stay over here. You cannot work on the B2 visa. So for that only, you have to go for the EAD. In that case, like that's what I said in the earlier time as well. So you have to go for it, and you have to go for the B2 EAD compelling circumstance, but we don't know when it's going to come up. But with the memo and everything, we are just kind of hoping it might come up as soon as possible. They will give the importance of it with the layoffs and everything going on to help the community, actually, so that, like if in that case, you can decide between B2 or an EAD compelling circumstances.
So what if we want to travel on B2 visa to India? So
you can leave the country after you filed. Say, for example, your 60 days is getting over, and then you filed, on the 55th day and sent out the documents, and then you stay for B2 for 2 months, and then you tried your best to find a H1B, and then you couldn't get any employment or any offer. If you decide to leave the country, there's no problem at all. You don't have to wait for the decision to come, and all that you have to carry is always keep that receipt notice, which claims that you had been maintaining your status after the 60 days as well. So that is the only proof that is needed. Even for sometimes the consulates are very, detailed, and they come back and say that you exceeded your stay when there is no pay stubs or nothing of related to the old employment. So all that matters is to hold on to your B2 receipt notice. That itself is.
okay. Thank you.
Good. So, any other questions from anyone? It seems like Aditya is live. It's fine. So, any specific conditions, So
yeah. So one more question I have. say if my employer wants me to go back to the country and they are not sending me back, can I come back in through some other company after getting a stamping?
Okay, so like so for you, your current employer is saying to leave the country, correct? And then you're leaving the country, right?
Yes, yes.
Okay, so once you go out of the country also, because you had been on a H1B, anytime, like you become a cap exempt actually. So, either you have an I-140 approval with you, anytime you can be from any new employer, they can file for you. If not, if you don't have an I-140 also, if you have not, within the 6 years, that you say, whatever the remaining period, any employer can file for an H1B and then you can go for, if you don't have a visa stamping, then you can go and then, like return back. Is it, does it, like, are you able to get it?
Yes, yes. Yeah, thank you.
All right. Okay, sure.
So the other, on the similar lines, Mary, is there any time limit? So once the resource leaves the country, so let's say the associate level is 3 years in US, and now he's leaving out. After how many years he will be able to come back? So is there any specific time?
No, actually earlier there were a restriction of within the 7 years period, and also that's no longer there. So they can, any time, even for if they had an H1B in 2007, 2008, actually. So they had been here for some more time. See, the cap exam works like this, okay? The visa stamping at least one time should be done. Without that, they don't become a cap exempt, or they should have been in US even for a shorter period of time, 3 months, 4 months. They had been in US actually, so that makes it cap exempt. So it doesn't matter with the limitation of the earlier time period, so they can anytime come over here, right? They can become a cap exempt, and that H1B can be filed for as a cap exempt H1B, and they can come.
Yeah, so I think I'm not seeing his name, but I think we discussed this case some time back. So you can check back the recording, and definitely if there are any questions, you can reach out to Mary's office. Mary, anything specific that you want to bring more attention about the concurrent processing, the H4 EAD concurrent processing? So any specific cases you want to bring?
Yeah, so all that I'm saying is now it's making it much easier. So so the problem is now it gives so much of an advantage for people who can file it together. So insist on your employer. Some of them, like they say that, like our responsibility is only for filing the H1B. So with the receipt notice, after the receipt notice, like you can file it through. So that cannot be said as a concurrent processing. So we are yet to see the result of it because the settlement agreement only came in. But again, the advantage over there, which is very good, as they were saying about even the premium processing, which was not expected actually. So if your H1B has been filed on the premium processing, in that case as well, right? Like, so you're just getting, if the H1B has been approved under premium processing, there's no premium fees that has been paid for a H4 actually. So it's always a courtesy that USCIS does it when they are processing the H4 along with the H1B premium processing. So earlier we used to see that as like, any premium processing gets approved with the H4 and H4 EAD. So after the biometric, they start the process, but the settlement agreement, it clearly says that either the standard or the premium processing, it will be concurrently filed along with the H1B. So if your employer at any time saying that, we'll file the H1B and then, H4 and H4 EAD, you can still file it. Then again, it's going to mess up the timeline, because it's going to be considered as a separate filing, even though you file it as through the receipt notice. So just insist that it has to be filed through my same attorney, and then H4 and H4 EAD fees can be paid by you directly to the law firms. So keep in mind, so it matters a lot. So just, don't lose that opportunity, and later on, just think about it. How do I expedite it? How do I call them? And how do I chat with them? And so many restrictions. And then, taking a break. And with the economy, you have to be very proactive to keep your job as much as possible, the continuity of job, rather than thinking about the payment and how it involves and everything. So just do that as something, an opportunity for you to get it, even though there are many options, right? So there are so many chaotic conditions that happen. The H4 is not approved, so either they have to travel out of country, then they have to come back and then validate that EAD receipt. Based on that receipt, they can continue to filing. So many things are going to be better. I don't know how the community is able to receive it, but definitely I see so many chaotic situations, and then so many jobs for these H4s are, most of them are women. So they would have started, and there is no, after a year with a break, there is a discontinuity of employment, and then they couldn't, right? No employer is ready to wait for they don't have an answer, whether it's with the California Service Center. If you look into it, 12 to 15 months of processing time for a H4 and H4 EAD. That's crazy. And who will be assured that when it's going to happen and all those things? So with all these, right, so this is a very good settlement. I know Jonathan Wasden, so we closely work with them as well. So definitely it was like a very commendable decision that has come up, and so you have to make use of it. That's what my always it's very, very much that you should be making use of it to file it concurrently and then go for premium if needed.
Great.
Mary, I have one question. One question in the sense, probably, I do have few cousins, so I'm just concerned that in case if their H4 is coming to an end, do you think in case if they have valid GRE scores and they are able to get into college, is the better option for them, that they'll be able to convert to a student visa?
I'm sorry, you mean to say H1 or they are on H4, you're saying?
Sorry, H1. Sorry for H4. Yeah.
So for a H1B, you're saying, when they're 60 days period, because of the layoff and then the 60 days period is approaching, then you're saying, is it better to file themselves to an F1 visa?
Yeah. So before, if they are able to get admitted into a college, is that a better option somehow that, right, in case if they don't want to move out of the country, and not sure how H1 will be valid still by then in case if they are able to get hold of another job, but
yeah, I think
conversion.
we discussed about it in the earlier time, but again, I'll just explain it to you. Okay. So when you convert yourself to a F1, the concern over here is, yes, you can do that to safeguard your status. You're not going to be out of status. So you're just definitely within the 60 days period. If they get an I-20 from a good school, and then they just file for it. So most of the schools, what happens is the F1 processing as well within the country is taking a longer time, actually, like 10 to 12 month time period. So most of the schools, when the F1 has been applied for, they don't allow them to take full-time classes, actually. So they do give 1 credit or something, 3 credits or something, 1 course or something, just to keep them occupied or keep them as a student, actually. So just to have them to just provide I-20, because USCIS sometimes might come back and ask for it. So in that case, I would say if they're serious enough to, so this can be a bridge status. That's a good question, actually, so that they are not losing the status as long as they have a valid I-20. All that they have to do is, instead of a visitor visa, also they can file themselves into an F1 visa and then apply for it. But the timeline is very long. So in case after the 2 months period, if they are coming, they have a good opportunity. If they want to, be on H1B as well, actually, say that they want to switch back to full-time H1B, definitely they can do that. They can definitely convert themselves to a H1B. But as I said earlier, they have to start working on H1B only after the approval of the H1. So that's also fine. But if they are very serious to continue their F1 status, I'm little concerned they will be able to stay in the country, but they cannot, they cannot be traveling out of, I'm sorry, they cannot be studying full time. So they have to just wait till the F1 gets approved and then they can take the full courses on the F1.
Okay, got it. Thank you very much.
Sure. So any other questions or what do we do? It's almost 5:56, Raj.
Yes, that's what I'm thinking. So I think
Yes, Sairam. Yeah, the last question we'll take from Sairam.
Yep. Good evening. Sorry, I've joined in a bit late. I just got to know. So yeah, I've got a question. Actually, one of my friend recently got laid off on like last Friday. So he's on a full time, but unfortunately, like they're not holding the immigration services anymore. So he's in the cap. That's like 5 days into the period, like 60-day period. So he's trying out to figure out the options as how the current job market is. He's trying on, he's like with full swing out applying jobs and stuff. But meanwhile, he's figuring out with the consulting firms, like, if they can transfer him with an in-house project, would that affect? So how does that work out, Mary? So any views
Yeah,
on
with
that?
the week time, it's going to be the LC itself takes 7 days period, and so I don't know, like if it's only a week, it has to be. But with the in-house project, right, like they have to be very clear about it. Like, there are many things that has to be in detail. Raj.
What is your skill set, Sai?
Yeah, my skill set is, I think it's Java full stack. Yeah.
Okay, so let's see if we can connect offline and see if we can help.
Yeah. So yeah. So Mary, like
Right, so the definitely, like, see, there's no client letter need as you all know about it, and so, but again, there are other criteria. But if the employer is willing to do it, and definitely it's between the employer if there is an attorney involved, and then the candidate if they have a full-time offer, and if it's a genuine in-house projects and everything. I think do it, or immediately I would say rather than jumping onto anything, it doesn't harm to file themselves to and B2. As I said earlier, there are so many cases we filed it last 2 days before, and then when they got the new employment after 20 days, they got the H1B approved on a premium processing with nothing of a major concern. So I would say filing on to going to B2 and then find an employment and then just do that will be the best thing to do.
Okay, so you mean to say, like, with the consulting, like, let's say if they're going, ask them to do a regular, and meanwhile, if they get any other opportunity, they can still go with the second option with a premium processing, right?
Yeah, that's correct.
All right, that makes sense. Yeah, I think that was the one question I was having, Mary. Thanks for answering that.
Sure. And if you need any help, we are always there to help you with the, the B2 status and everything. We have you have the email ID, and then you can do it as well.
Yeah, sure. Thank you.
Okay. And then somebody's asking about, H4. It's H4 EAD depends on the, service center. The California is the longest, and the Vermont and the Nebraska's, if you have filed it, it all depends on the H1Bs, right? So depending on that, but now I think it's definitely going to be much better. The processing timeline is going to improve a lot. You don't have to wait for months and months to get the EAD. And I think Devi has a question. So with the Devi, can we finish it up, Raj?
Yeah. My name is Siva. Hi, Mary. And currently I am on F2 visa, and
Okay.
my param status still pending. Hopefully, by next month, I may get a status. And after that, my employer filing I-140. So my question is if my H1B got approved, right? So in that case, do I need to exit the country to get stamping, or still since because of I am on F2 visa within the country itself, I can apply for change of status?
Yeah, that's, see, you are on an F2 status. Yeah, definitely, we have filed it, because of the delay with the perm and all those processes at such itself. So many situations we have done it, and we insist, when we file it, that we want, because of the delay with the visa and traveling out of country when he has an offer, and the only reason he was not able to continue is we call it non-proton, and then we add up other criteria. And then, we definitely try our best to get it, and we were able to get it, even though I can't guarantee anything that it is going to happen. But definitely, it helped actually.
Oh, okay. Okay, okay. So in that case, like if my H1B approved, right? So in that case, I no need to exit the country to get it
No,
stamped, right?
yeah, that's what I'm saying. You don't have to,
Okay.
and then your attorney has to add up all those
Oh,
details, and then and then file for it. And if you need anything, you can send an email, and we can
sure,
I
sure.
can ask the office
Sure.
to do the detail. Okay.
Thanks, Mary. Thanks.
Okay.
Yeah, so thank you all. Thanks for your participation and asking questions. So this always keeps us motivated and do more sessions like this. Again, I know it's a pretty short, quick. It's a very within a short notice. We got a very quick turnaround. Thank you all for your participation and asking questions. Looking forward to see you all in the next special sessions. And again, without saying, Mary, thank you very much. You're always there for the community and people.
Sure. Anytime, Raj.
That is very great of you, Mary and Raj, facilitating this. Actually, it's really helpful during these times, I think, for our community. Thank you.
Sure. Thank you. That's nice.
Yes, really, Mary. Thank you.